Hello, welcome to the Legal Aid New South Wales Law webinar on legal words for interpreters. My name is Jenny Hanson and I'm here with Jessica Sullivan. We both work in the Community Legal Education branch at Legal Aid. We're recording this webinar from Legal Aid New South Wales' Central Sydney office. So I want to acknowledge and pay my respects to the Gadigal people of the Eora Nation, who are the traditional owners and custodians on whose land we are recording this session today. Now, before we start, we'll just quickly set the scene about what the webinar is about and what you as interpreters and bilingual workers will hopefully be able to take away from this session to help with your work in courts, legal advice, mediations, and in other legal settings. And hopefully after this webinar you'll be more familiar with some legal words we use in criminal, family and civil law, and you'll also know where to look to get more help with resources. First, I'll talk about legal aid. I'll be using words we often use here. That might help you when you're working with legal aid. So, free advice. Anyone can get free advice at Legal Aid. You may be asked to interpret for an advice session. Advice sessions will last about 40 minutes with an interpreter. Lawyers might fill out legal aid forms at advice sessions. This is called applying for a grant of legal aid. If this form is accepted by Legal Aid, then the person will get a lawyer to give them more help with their problem. Minor assistance. Legal aid lawyers might talk about doing this for a client. It means they will write a letter or make a telephone call to help their client resolve their legal problem. Duty services at court. This means there is a lawyer at the court who will help on the day as a one-off service, and they're called a duty lawyer. Ongoing help from a lawyer. For a person to get a grant of legal aid, there is a means test and a merit test. The means test is looking at a person's money and assets, and a merit test means looking at whether the case has a good chance of success. And finally, community legal education. Interpreters and bilingual workers might be booked for community legal education sessions, such as sessions for newly arrived people in the community. Here are some statistics about our clients at Legal Aid. Legal Aid New South Wales provides services to socially and economically disadvantaged members of the community. Our clients have a wide range of complex legal, social, psychological and physical problems. Clients' issues may be compounded due to their lack of English proficiency, low levels of education and literacy, and disability. Often you'll find you have to interpret words which are rude, offensive or embarrassing. Many situations may be distressing, such as child abuse, sexual assault or domestic violence. Situations will be discussed which are kept silent in many cultures or be embarrassing, for example, marriage or relationship breakdown, family violence and financial issues. You'll have to interpret words about private body parts, sexual words and swear words. Please do this. And if there are problems, such as no words in your language, please talk to the lawyer about the problem. So sometimes our lawyers are pressed for time because of the way that courts operate or the number of clients waiting for them. If they're speaking too fast, it's okay to ask them to slow down. I'm just going to hand over to Jessica now to talk to you about some legal words about courts.
Hello. Okay, so some of the words that are used in court that you may hear will include prosecutor, applicant, plaintiff or complainant. Now this group of words means a person who starts legal action or a legal case in court, tribunal, commission or a dispute resolution scheme. The words plaintiff and applicant are used in family and civil law cases. The word complainant is usually for making a complaint to police or in a tribunal, commission, or in a dispute resolution. The word prosecutor is normally used in criminal law. Defendant, respondent, accused. This group of words refers to a person or organisation who has a legal action or case taken against them. Party. This is the people or organisation who are directly involved in the legal case or action, such as the plaintiff and defendant, or the applicant and respondent. A judge can decide that other people can become parties. If so, the judge makes a court order to join parties to the case. Registrar, judge, and magistrate are different. Registrar is a senior legal officer at court who provides the public with legal information, makes administrative decisions, and may decide some less complicated matters. A magistrate hears and decides civil and criminal law matters in the local court. Lawyers call the magistrate Your Honour. A judge hears and decides civil and criminal law cases in the higher courts, such as the District Court, Supreme Court, High Court, Federal Court, and Family Courts. Lawyers call the judge Your Honour. A mention is a short court appearance where a party may ask for an adjournment, or the court can set a hearing date or give some other directions. The first time parties go to a court in a case is usually called a mention. For example, a lawyer might tell a client, "Your case will be mentioned in the court today." Adjournment is to suspend or postpone the court hearing to another time or another place. The registrar, judge, or magistrate will make this decision. It is usual to ask for an adjournment at the beginning of a case, before the lawyers have had time to talk to their clients. It can also occur later if the judge thinks there are good reasons for a delay. Hearing. This is when the full court case is in front of the judge or magistrate. It is the time when the parties present their evidence to the court and make submissions on the law that applies to the case. At the end of the hearing, the court makes a decision. Some words about documents. Affidavit is a written document containing evidence for the court. It contains factual information about what the person or witness saw, heard, or felt. An affidavit is signed in front of an authorised person, such as a lawyer or a justice of the peace, and sworn or affirmed to be true. Statutory declaration, or you might hear a lawyer call this a stat dec for short, is a written statement declaring that what it says is the truth. The statement must be affirmed or sworn in front of an authorised witness, such as a solicitor or a justice of the peace. Statutory declarations are used more widely than affidavits, which are only used in courts. For example, a stat dec could be used for passports and to obtain documents like birth or marriage certificates. I mentioned that affidavits and stat decs must be sworn or affirmed. Now these are different. An oath is a sincere promise to tell the truth, sworn on a Bible or other religious text, whereas an affirmation is to solemnly promise to tell the truth in court or in an affidavit. An affirmation is made instead of a religious oath. Subpoena, a court order telling a person or organisation to bring certain documents to court or to appear at court to give evidence. This can be used in a few ways. For example, the court has issued a subpoena for those documents, or those documents have been subpoenaed to court. Criminal law. Criminal law involves offences against the community, such as stealing, assault, drug dealing, sexual assault, or murder. Crimes can be punished by fines, prison time, or sometimes what is called a good behaviour bond. If you want to know more about criminal law, look out for our workshops and webinars. Criminal law is the largest part of legal aid work and the largest section of legal aid. The criminal lawyers at Legal Aid assist people charged with criminal offences, who are also called defendants, that are appearing before the courts. Our specialist criminal law services that we have include the Children's Legal Service and Youth Hotline, the Drug Court, and the Prisoners Legal Service. These are some words that you might hear in relation to the criminal process. Arrest, to be taken into police custody for committing or being suspected of committing a criminal offence. Offence, which is something that the law says is wrong. Charge, when the police formally accuse a person of committing a criminal offence, so someone gets charged with an offence. Bail, the release of a person from custody after they have been charged with a criminal offence, on the condition that they return to court on a certain date. Other conditions may also be included, such as regular reporting to a police station and payment of money. Plea, which is when a person tells the court whether they are guilty or not guilty of an offence. So you might hear a magistrate or a lawyer ask someone, "How do you wish to plea?" Guilty, when a person admits they have committed a criminal offence or the court decides that the person has committed a criminal offence. Not guilty, when the court decides that person did not commit a criminal offence or they committed the offence but they had a defence, which is a good reason for doing something that the law recognises as a good reason. Trial, a criminal law court case. Sentence, the punishment imposed by the court if you are convicted of an offence. So if you're found guilty or plead guilty. And these are just some words about criminal law. Custody, which is to be in the care and control of police at a police station or another place of detention, such as in prison. So you might hear a magistrate or judge say to a defendant, "You will be kept in custody." A summary offence, which is a minor criminal offence dealt with in the local courts, which is the lowest level of court in New South Wales, before a magistrate. An indictable offence, which is a serious criminal offence where you may have to go to the higher courts, the District and Supreme Court, and possibly where a jury will decide the case. Acquit, when a court decides that a person did not break the law, they acquit the person. This is the same as the court deciding someone is not guilty.
So we're going to move on to a different area of law now. Legal aid also helps people with family law problems. Family law is about what happens when people's relationship breaks down. Anyone can use the family law system, whether they're married, de facto, heterosexual, or in a same-sex relationship. However, if people can work things out for themselves, they don't have to use the family law system at all. The main areas of family law are divorce, which is the end of a marriage, and it's granted by a decree of dissolution of marriage. Children. Disputes about children are the main area where legal aid works. Child support is a payment made by one parent to the other to help with the cost of looking after children, or a payment made by one or both parents to a person who has care of their children. And property, which is disputes about property. If you're interpreting in a family law advice session or in a family court, these are some terms you might hear used. The best interests of children. This is the most important consideration when a court makes decisions about a child. Equal shared parental responsibility, or you might hear it abbreviated to ESPR. This is equal decision-making shared between parents about the big issues concerning children, such as where they live, where they go to school, their religion, culture, and major health decisions. ESPR does not mean equal time. Where children live and who they spend time with are separate issues. Family law does not use the words custody and access anymore. This is because they wanted to remove the idea that children were owned by parents and that one parent wins or loses, and to emphasise that both parents have responsibilities about children, that parents do not have rights, they have responsibilities. So, custody and access has been replaced by talking about where children live and who they spend time with. In a contested matter where the court makes orders about children, these can be called lives with orders and spends time with orders. An independent children's lawyer is a lawyer appointed by the family court to represent the child's interests in parenting cases. Sometimes in a family law or child support matter, proof of paternity may be relevant. This is proof that someone is the father of the child and may involve court orders for paternity testing. So now we're going to look at some words about family law processes. Mediation or family dispute resolution is compulsory in children's matters in family law, except where there is domestic violence or the matter is urgent. That means that it's very possible that interpreters may find themselves assisting clients with a family law mediation, called a Family Dispute Resolution Conference. This is often abbreviated to FDR or FDR Conference. So mediation means confidential meetings where an independent third person, a mediator, tries to help parties to a dispute come to an agreement about their matter. Family Dispute Resolution, or FDR, is mediation that assists families to reach agreement in the best interests of children. Agreements can also help with property and financial matters. A parenting plan is an agreement by parents about what is best for them and their children. This is often done with the help of a mediator or family dispute resolution practitioner. A consent order. This is a court order made by a judge with the consent or agreement of the people who have been in dispute. Sometimes parents will decide, after getting legal advice, to ask the court to turn their parenting plans into formal consent orders. So now we're going to go back to Jessica to talk about civil law.
Civil law. Civil law problems are everyday problems that have a legal side to them. At Legal Aid, we call civil law law for everyday life. People know they have a criminal law problem because the police are involved, or a family law problem because their relationship is breaking up. But they might not know they have a civil law problem. Civil law covers a very big area. This includes issues about finances, money, accidents, property, contracts, and wills. At Legal Aid, we do not cover every area of civil law. Instead, we focus on those areas which impact on our target groups: economically and socially isolated and/or vulnerable people. Areas of civil law where Legal Aid New South Wales provides a service include government law, or immigration, social security, or Centrelink; discrimination and employment. Unlawful discrimination is unfair treatment which is against the law, such as not being offered a job because of your race, sex, or disability. Consumer law, including credit, debt, and mortgage matters, as well as help with natural disasters, for example, with insurance companies. Mental health law and guardianship law. These laws are to protect adults with cognitive or mental disabilities, mental illness, or intellectual disabilities who cannot make life decisions. Guardians are then appointed by guardianship tribunals to make these decisions. Legal Aid also has a coronial inquests unit. An inquest is an inquiry by the state coroner into a death or event such as an explosion or fire. And another term you might hear in relation to civil law is Work and Development Order, or a WDO. And this is a program for disadvantaged people to help them pay off their fines by undertaking unpaid work, courses or treatment programs with approved organisations or health providers. If you are interpreting for a civil law matter, particularly in a court or tribunal, here are some words you may hear. Duty of care, which is the duty a person or organisation has to look after another person or care for them, such as an employer making sure all health and safety rules are followed, or a hospital is doing all it can to make sure they give the best treatment possible to their patients. Another example might be a shopping centre making sure their premises are safe and that people don't fall over rubbish or boxes left everywhere. Negligence, where a person has a legal duty of care, but they break it and causes the other person to experience loss or damage. Statement of claim, a court document used to start a court case about a debt or other civil law cases. Damages, money claimed or awarded by a court to compensate a party for loss or injury. For example, in a car accident case, damages may include the costs of repairs to a car, hiring a replacement car, or replacing items which were in the car at the time of accident and were damaged. Terms of settlement, a document that records how two or more parties have agreed to settle a civil law case. These are just some of the decision-making bodies which take complaints, mediate, or hear civil law issues. There are many more. Firstly, the New South Wales Civil and Administrative Tribunal, which you might also hear called NCAT, deals with a broad and diverse range of matters from disputes about residential tenancy and building works, consumer claims to guardianship, discrimination, and administrative review of government decisions. Administrative Appeals Tribunal, which is also called the AAT, a federal tribunal which reviews decisions made by government departments. Examples of decisions it reviews include family assistance, paid parental leave, social security and student assistance, migration and refugee visas, visa-related decisions, discrimination, taxation, and veterans' entitlements. The Fair Work Commission, which is a tribunal to help people resolve employment disputes. The Office of State Revenue, which is a government agency that administers the New South Wales fine enforcement system and is responsible for the receipt and collection of outstanding fines and penalties. The Ombudsman is a person and office who receives complaints about the decisions of public and private entities and tries to settle them. For example, the New South Wales Ombudsman receives complaints about police and New South Wales government departments. There are many different types of ombudsman. For example, there is a financial ombudsman service, a credit ombudsman service, an insurance ombudsman service, and a telecommunications ombudsman. In civil law matters, you might hear a lawyer talk about someone going to a financial counsellor. This is someone who assists people with financial problems. Many financial counselling services are provided for free by non-government community or welfare organisations.
Now we're going to show you some resources if you want to look up more legal words. We've only done a small introduction to a few words today, so you can use these resources to help you find out more. Law Access New South Wales have definitions that are really clear and easy to understand. We've used Law Access a lot for this webinar. You can find this in the Representing Yourself section in Law Assist on the Law Access webpage. Legal Aid Victoria. So this is a glossary from Victoria Legal Aid, and they're our counterpart in that state. This glossary was done by the Federal Court, and it was done in order to help self-represented litigants, but you might find it useful as well. Macquarie University has made this online resource for family law words. Look on the left-hand side There's a box to search for terms, and there's also translation options to help you. Thank you very much for listening to this webinar today on legal words for interpreters and bilingual workers. We hope you feel more confident now with some of the words you will hear when interpreting in courts, advice sessions, mediation, and other legal settings. If you're interested in legal aid publications, please go to the publications page on our website. You can look at the Community Legal Education page for upcoming live webinars and also face-to-face workshops.